report number 2. It will also deal with legislative response to the recommendations, including the changes that are directly related to the program. I'm going to speak to you for probably about the next 10 or so minutes. As to the background of the program, I'll give you an overview of the relevant legislative changes to support the first stream of the changes for this panel. Tonight is mostly dealing only with Stream 1, but we will briefly touch on aspects of Stream 2, which is yet to be commenced. After I speak, the program team will step you through the pilot itself, the requirements, eligibility and program operations in some more detail. There has been plenty of time allocated for questions, so don't feel shy. And we have a facility monitoring the virtual attendees for any questions that they may have. Now, as this is a practitioner information session, most of you should be used to dealing with this sort of material. But can I just simply say that if anybody feels any distress, and it can happen, and it can happen at the most unexpected times, feel free to deal with it in any way you see fit, including leaving the session if that is the way you choose to deal with it. There's one other preliminary issue that I want to deal with, and just so that people understand, we are using different terminology in different stages of this presentation and indeed in all of our dealings. When we are referencing the task force and the literature used by or coming from the task force, we may make reference to victims or victim survivors. That is because that is the terminology that has been used in those contexts. In other instances, we will be referring to the terminology of a complainant, which is, of course, the usual terminology within the criminal justice system. Can I speak to you about this slide first, more as a preface to the outline of the background, to the legislation and to the creation of the panel. To assist with the implementation activities which have resulted from the reporting, the Department of Justice established a steering committee for the implementation and oversight of the panel pilot project. As I've said, I'm the chair of the steering committee. Other members of the committee come from a wide range of organisations. They include the legal profession, the Office of the Director of Public Prosecutions, various government agencies including the Queensland Police Service, Queensland Health, Youth Justice, the Office of the Victims Commissioner. We have facility for bringing in other representatives from other departments on an as-needs basis. The steering committee is a decision-making forum which generates input into the direction the pilot is taking. It contributes to the development of the relevant policies, procedures, training and communications to support the implementation of the scheme, and it identifies and tries to mitigate risks and issues so as to maximise the effectiveness of the panel for all involved. The Expert Evidence Panel Program Team, it's just easier to say the program team, quite frankly. It provides what has been and will no doubt continue to be excellent support to the committee. The program team will continue for the duration of the pilot. So let's turn to the background to the panel. The Women's Safety and Justice Task Force in Hear Her Voice report number 2 recommended the establishment of a sexual offence expert evidence panel in this state. There are 2 recommendations which are directly relevant to the panel, and they are Recommendation 43, which as you can see refers to amendments to introduce affirmative consent into the law of rape and sexual assault. It recommends changes to the mistake of fact defence and provides for an affirmative consent safeguard provision, which is centrally important to this panel. It also recommended that none of them should commence until the expert panel for sexual offence trials has been established. Strictly, that timeline wasn't followed, but it is because of the transitional provisions and the timing of when the legislation took effect. The second recommendation directly relevant is recommendation 80, which proposed that the department establish the Sexual Offence Expert Evidence Panel for sexual offence proceedings and that it can be used by the prosecution, defence and the court. Now that again is referring to the two streams. We're really going to concentrate here tonight just on the one stream. Can I say that the recommendation for this panel was in part influenced by an interstate recommendation for a similar body? I'm not aware whether the interstate recommendation was adopted by the relevant government, but I can tell you that it hasn't commenced. So we have been dealing with a blank sheet and trying to create from there. And in that respect, can I pause just to again note the excellent work that's come from the program team in developing all of this. That piece of legislation that you can see on the screen introduced the affirmative model of consent in this state, and it established various complementary legislative changes and also the framework for the expert evidence panel. The affirmative consent laws commenced on the 23rd, September of 2024. It applies only to offences charged as being committed wholly after that date. That created a gap in a practical sense between the need for the panel to be operational and the commencement of those provisions. I'm sure that most, if not all of you, are familiar with the provisions. Broadly, they emphasise the need for communications between the parties to a sexual interaction. Consent must be free and voluntary, and it must arise from something said or done. There must be an agreement for both parties to take part in the sexual activity. Pursuant to section 348 capital A subsection 3 and of particular relevance for tonight's proceedings, an accused person can no longer rely on a defence of a reasonable but mistaken belief in consent if the defendant has failed to say or do something to ascertain whether the complainant consented. Section 348, capital A, subsection 4, provides an exception to that requirement that I just spoke of. You can see it there. It does not apply where a defendant had a cognitive or mental health impairment at the time of the sexual act and the impairment was a substantial cause. Yes, the impairment was a substantial cause of the defendant not saying or doing anything. There is requirements in section 348 capital A that a defendant relying on this exception must adduce evidence from an expert. And this is where the panel comes in. If the expert reports have been obtained or report has been obtained, it may be that it will be adduced in any trial. But that is a precursor, a prerequisite, as it were. The task force considered that this safeguard, that is the provision of a panel to provide access to experts, was critical if this state adopted the affirmative consent model. Otherwise, people with an impairment affecting their ability to communicate could be unfairly disadvantaged by their failure to take steps to ascertain consent. The onus is on the defendant in these situations. In establishing the safeguard provision, a defendant must adduce the expert from the evidence in order to rely on it. I'll come to the provisions around the notification of time when that must happen in due course. A party may, but do not have to, engage an expert from the panel to testify in a proceeding, and if the proceeding is in a location, I'll start that again. If the proceeding is in a location covered by the pilot project, that is Brisbane or Townsville, the party does not have to access an expert from the panel, but can. If the trial is outside of those two centres, for the purposes of this pilot period, there will not be access to the panel. The defendant will have to engage privately. Put another way, a defendant in a pilot location of Brisbane or Townsville is not stopped from privately engaging an expert, and any parties outside of those areas will need to adduce the expert evidence if the provision is to be relied upon, but it will have to be privately funded. Pilot project locations have been implemented by way of an amendment to the Evidence Regulation of 2017. From 3 February 2025, it will be the District and Supreme Courts in Brisbane and Townsville as the places where the expert panel may operate. As you'll come to understand in a moment, the magistrates' courts which are affected are not only Townsville or Brisbane Central, but any of the magistrates which would feed in by way of usual committal processes into the District or Supreme Courts in Brisbane or Townsville. The Chief Executive or his or her delegate is required to establish and maintain the panel of experts in conformity with the various provisions in Part 6 Capital B Division 4 of the Evidence Act. For those of you, much like myself, who prefer to hear section numbers, it's 103 ZZC to 103 ZZK. There are requirements such as section 103 ZZH, which mandates that the Chief Executive or delegate must be satisfied the experts appointed for Stream 1 operations have specialised knowledge gained by training, study or experience in various fields, namely psychiatry, neurocognitive psychology, or a field of knowledge relevant to assessing the impairments and the effect on the defendant's ability to communicate. The panel, or during the pilot program period in any event, the program team will provide and fund the experts to testify in the matters before the courts in which they're engaged. Now, the Evidence Act will be subject to further amendment when relevant provisions from the Criminal Justice Legislation (Sexual Violence and Other Matters) Amendment Act of 2024 commence. That Act was passed by Parliament in September of last year. There has been no proclamation date and none of the provisions have commenced as of yet. Part of the function of this particular legislation will expand the panel's functions to allow for the admission of expert evidence in criminal proceedings about the nature of sexual offences and the factors that may affect the behaviour of a complainant. That is Stream 2. As I say, it's not yet in force. Once it is known when those provisions will commence, there will be a further information session so that the profession can be brought up to date. Just coming back then to Stream 1 and the affirmative consent model and the intricacies and the effect, if you like, of Section 348 capital A of the Code. They must, that is a defendant who intends to rely on the provision, must notify the prosecution within 14 days of committal. Let me read Section 590 capital B capital A subsection 1. If an accused person intends to adduce expert evidence under 348 A6 in the person's trial, the accused person must, within the prescribed period, give notice of that intention. The prescribed period is 14 days from committal. That is the same period provided for notices of alibi. It differs from section 590 B concerning other expert evidence, which you'd all be aware of. It is an important feature about this scheme, and it is why I have highlighted that the magistrates' courts dealing with committals to which this may apply, or to which the scheme may apply, are not limited to Brisbane Central or Townsville. It is any magistrates' court which feeds into the Brisbane District or the Townsville District and Supreme Courts in each instance. It is envisaged, there is provision for leave out of time. What is envisaged, however, is that the notice of intention would be provided very shortly, that is within 14 days after committal. That will require the profession to give consideration prior to committal, because you don't know if you're going to intend to rely on the report until you get the report, and they will take some time. We don't know how long at the moment, but they will understandably take a period of time. Section 590 B also provides for the requirement that the notice is in writing and given to the Director of Public Prosecutions. It is taken to have been given to the Director of Public Prosecutions if it is left at the office of the DPP or is sent by certified mail addressed to the Director's office. They are the matters that I wanted to highlight at the moment. This is a big change in the legislation. It is a big change in common law dealing with concepts of mistake of fact with those who are intellectually impaired. Importantly, there is the necessity, if a defendant is to rely on 348 A subsection 3 and 4, for them to obtain the report, and they bear the onus. The onus is not stated to be at any particular level. Ordinarily, that would mean it is on the balance of probabilities. On that note, I wanted to hand over to the rest of the program team. They'll speak to you about the excellent work that they have done and will continue to do. And I think I'm initially handing over to Christy Lee.
Thank you. Thank you. Thank you so much. Thank you very much, Judge Byrne. I'm going to take a few minutes now just to talk through some of the key parts of the program, focusing on how the referral process works. There we go. And then I'll pass you over to our program manager, Kate, as well. So the first part in the process for Stream 1, once a case is deemed eligible, is identified to complete a referral form. Referrals can come from either the legal professionals or self-representing litigants. Referral forms can be found on the Court Services Queensland website, and we have a dedicated page for the program. So along with the referral form on there, the webpage is going to host a suite of resources related to the program to support you through using that, including at this stage we have the procedure manual, the code of conduct and the scheme rules, as well as our contact details if you have any questions in the meantime. And it's envisaged we'll use that webpage as well just to continue to upload resources as we identify a need. The form is in a PDF format, so it can be completed electronically and submitted directly, or if it's easier for yourself or your client that you're working with, you can print it out, complete it manually and scan it and email it back to the program team, or even post it, whatever works best for wherever you are at the time. We are asking for a bit of information via the referral form, so I'll just run through a little bit and give you an example of what we do need. We need the requesting party's details, information about the alleged offence, information about the defendant, including things like their cultural background, information about any mental health history or suspected mental health or cognitive impairment or disability that you may have. Any other identifying information about the defendant as well is very useful. We do request some basic information about the complainant, mostly like date of birth and names, some real small details, but that helps us to screen out any potential conflicts of interest throughout the process. On the slide here, we've just got a bit of a snapshot of the form to provide a visual of what it'll look like. But if you need any support, you have any questions at all, you're unsure if a matter that you're working on is eligible for the program, please contact the program team by email, phone. We'll pop our details up there. But as Judge Byrne mentioned earlier, it is a pilot. We haven't done it before, so we're going to be kind of learning together. So the referral process, once the program team receives that referral form, the requesting party will receive a letter of acknowledgement as confirmation that it's been sent through, and the program team will then get to work matching an expert to the proceeding. So when they're doing this, the team will be looking at the expert's availability, their areas of expertise, and the professional experience that they have. As part of this process, the program team will then send a letter of engagement to the expert they're hoping will work on the case. Once the expert's accepted that request, they'll notify the program team via a signed letter of engagement, and the program team will then pass on communication details to the parties. So from there, the program team will take a little bit of a step back in the communication, and that will be directly between the expert and the requesting party. The expert will then get to work with the assessment and developing the report, which will be sent directly to the referring party. Confidentiality of the program means that as part of the program team, we won't see those reports in full. They are kept confidential. For quality assurance purposes, at some stage we may ask for de-identified reports to observe, but we won't be storing those anywhere. Under the scheme rules, a particular number of hours of the expert's time are covered for them. If additional work's required, the expert can liaise directly with the program team. It's not up to the requesting party at all to engage in those conversations or have any discussions with the expert on those. So if you do receive any questions as a requesting party, please feel confident to refer them back to the program team, and we'll support the experts through the reimbursement process. Once the work's completed, the expert will apply for that reimbursement directly with us. If the expert is subpoenaed to provide evidence in court, they'll be reimbursed for any extra work that occurs there as well. Under the Evidence Act, the expert is permitted to ask for particular information, including copies of indictments, witness statements, and exhibits from the prosecution. The scheme rules in the program really clearly dictate the expert must access these from the requesting party and not from prosecution for Stream 1. And so the program team, Judge Ben kindly introduced us earlier, but I'll just show you who we are at the moment. So Courtney Undell, Director of Evidence Services, will be supporting us through answering any questions later tonight. Kate Phillips, our Program Manager, who we'll be hearing from shortly. Myself, Christy, so as Project Officer, my main role is working on developing some training modules for our experts. And then we have Trixie, who is currently supporting our virtual attendees tonight as well. There's potential that the team might expand throughout the pilot program, just depending on what needs are identified as well, but that's the 4 of us for now. And our main responsibilities include managing the recruitment and maintenance of the panel of experts to be included. So it may be that it is, we may hire more experts, depending on how busy the program becomes. Assigning experts to matters based on their field of expertise and facts of the case. Overseeing the expert's appointment process, including liaising with parties to a proceeding in the court regarding referrals, and making recommendations to the Chief Executive when necessary if an expert's no longer deemed suitable to give evidence in a sexual offence proceeding. And so here's how you can contact us. As I mentioned, these details are on the website as well. They're on the flyer that was out the front earlier if you wanted to grab one. But we are located in this building on level 1, Monday to Friday in business hours. We have a team phone number and an email that you can send any inquiries to as well. And that's all from me. Thank you very much. I'm going to pass you over to Kate Phillips, our Program Manager.
Thank you, Christy. I will now speak to you about the panel, starting off with selection criteria for panel members. As Judge Byrne mentioned, under Section 103ZZH of the Evidence Act, an expert for Stream 1 must demonstrate specialised knowledge gained by training, study, or experience in psychiatry, neurocognitive psychology, or a field of knowledge relevant to assessing cognitive or mental health impairments and the effect of those impairments on a person's ability to communicate. In order to be accepted as an expert onto the panel, all applicants were required to demonstrate the following in their applications: specialist knowledge, expertise and qualifications in assessing mental health and cognitive impairments, an understanding of how culture, race, ethnicity, age, disability and other intersectionalities may impact upon individuals and the community generally, specialist knowledge and experience in dealing with matters that involve sexual offending. Following a procurement process, 12 Stream 1 experts have been appointed to the panel. They have backgrounds in either psychiatry, neuropsychology and forensic psychology. All applicants were also required to undertake background checks and mandatory training about the program, their role, as well as other topics around cultural capability and trauma-informed practice. Panel experts are bound by a strict code of conduct, which is outlined in the panel's scheme rules and code of conduct document. This document is available for viewing on the panel's webpage on the Courts Queensland website. The code of conduct obligations include: the panel expert has a paramount duty to assist the court. The expert is not an advocate for a party to a proceeding and must not accept instructions from any person to adopt or reject a particular opinion. The panel expert duty to the court overrides any obligation the expert may have to any party to a proceeding or to the program team, who is liable for the panel expert's fees and expenses. There is an obligation held by the panel expert to inform the requesting party and/or court promptly if and when the expert's opinion changes from that contained in the written report provided to the requesting party or given in evidence during a proceeding. The panel expert must comply with an order made or direction given by the court. It is a requirement that the expert on the panel provide an expert report to the requesting party. By expert report, we mean a report prepared by an expert in their field of expertise and relevant to the facts of case or matter in issues. For example, experts are engaged to provide an expert assessment and opinion of the extent of any cognitive mental health impairments, its impact upon the defendant, and whether the impairment was at the time of the act a substantial cause of the defendant not saying or doing anything to ascertain whether the other person consented to the act. More specifically, experts must include the following in their reports: the expert's qualifications and place of employment, all material facts, whether written or oral, on which the report is based, the expert's reason for each opinion expressed in the report, references to any literature or other material relied on by the expert to prepare the report, references to any matter the expert considers significant, for any inspection, examination or experiment conducted, initiated or relied on by the expert to prepare the report. It must include the following: a description of what was done, whether the inspection, examination or experiment was done by the expert or under the expert's supervision, and the name and qualification of any person involved and the result. Moving on, I will now speak to you about some key program dates for the team, for the program. The Expert Evidence Panel program team are hosting 2 more information sessions in the coming weeks. We will be speaking to members of the judiciary on Wednesday, the 29th of January, and holding an information session for the legal profession and other key stakeholders in Townsville on Wednesday, the 19th of February. And as previously mentioned, our referrals for the program will open on the 3rd of Feb 2025. As also mentioned earlier, it is expected there will be a Stream 2 of the pilot. In Stream 2, an expert can be utilised by the prosecution, defence or court to give evidence about the nature of sexual offences and the social, psychological and cultural factors that may affect the behaviour of a victim or alleged victim of a sexual offence. Stream 2 of the pilot is still very much in the design phase, and information on this stream will be released as development begins. The design and development of Stream 2 will follow the same format as Stream 1 with oversight and input from the steering committee continuing throughout the process. For further information on the pilot, please be sure to visit our website. Further information will be available as the pilot progresses. All updates, resources and relevant dates will be on the court's website, accessible via the link on the screen. That wraps up the presentation for this evening. I will now hand over to Judge Byrne and Courtney Undell, who will take questions. And I have a microphone. Thank you.
Anybody got questions?
One moment.
Judge, I just have a couple of questions. The first one is, if the report is obtained for the defendant, it then becomes an expert report, and it's then up to the defence whether they disclose it based upon their intention to rely upon it.
Correct.
The second issue then is, whose responsibility is it to organise the witness to attend, the expert?
For the expert to attend, it becomes the responsibility of the program team liaising with the expert, and then also liaising with the parties as to the progress of the trial.
And the financial question then that follows from that, the program covers costs of travel and attendance by the expert?
Yes.
So neither party has to bear that cost?
Correct.
And is it envisaged then that the prosecution may then call their own expert?
Yeah, well, there's no express provision about it, but I think the only correct answer to that has to be yes. If the intention to rely on the expert's report is divulged within the prescribed period of 14 days after committal, that should allow considerable time for the prosecution to obtain an expert report in reply. Your next question is going to be, where's the power to do it? And I haven't looked up the paragraph number, but one of the paragraphs under 590AA subsection 1 talks about the obtaining of reports.
And if the Crown expert requires to interview the defendant, how is that contemplated?
Well, that will be the argument under 590AA.
Because obviously in the mental health space there is authorisation for that to occur to enable the competing experts to do that. And then the final observation then is...
Just while you're on the mental health court though, I don't know if the practice direction's still in play because I've been out of that arena for a while, but there was a practice direction that gave automatic right to use all reports in criminal proceedings that were obtained in the mental health court. That won't apply here.
Won't apply as in, if we have reports from the mental health court, you don't consider we'll be able to rely upon them in this?
No, sorry. What I mean is that there won't be an automatic disclosure of any reports obtained by the panel.
And the final question then is the sequence of events, because the onus is on the defence. Will it be similar to a diminished responsibility circumstance where the Crown expert will then be called in rebuttal after the factual basis has been established for the report and the expert has given their evidence, as against a requirement for the Crown to make it part of their case so that they've got to effectively have a preemptory strike about what the evidence is going to be?
The only answer I can give to that, Todd, is I don't know, because as you'd be aware, there's divergent case authority on whether it can be called as rebuttal or needs to be led according to Soma and the Queen as part of the Crown case. I do note, however, that this is more analogous to a diminished responsibility situation, so it may be that that line of authority applies, but I don't know. That'll be a matter for the trial judge, quite frankly.
Well, the only observation I'll make is it will depend on what the factual basis is that the expert is finding, so it won't necessarily just be an interview with the defendant. There may be other materials and things that they rely upon that they may need to leave in evidence that aren't part of the Crown case.
Yes, quite so. It will be fact dependent in that sense.
I did say that was my last question. I have one more.
It's all right. I've known you a long time.
No, I was just thinking about the sort of numbers that we're talking about, right? So that intellectual impairments with respect to dealing with it in the criminal matters, not a lot of those matters make it to the court for various other reasons. Has there been some modelling done on the expectation of this? Because obviously one of the issues is then around listings and expert availability, being able to spread those matters out, particularly for sharing between here and Townsville, as to how the logistics are going to work in that space. So
there's been modelling attempted, but not successfully, because this is leading the charge in this country. We have reached out to various jurisdictions to try to understand aspects of their statistics, that is of affirmative consent model jurisdictions, to try to understand how aspects of it are working in those jurisdictions, but there's variable statistical gathering quality across the different jurisdictions, so we haven't succeeded in that. That is very much one of the question marks we have as to how much uptake there will be on this. On the other side, this is creating a information giving process and hence an education and training process for the profession, which we are hopeful will lead to increased pickup of issues. Personally, I will not be at all surprised if, perhaps not immediately, but over time there starts to be a lot more things like FASD being picked up and identified than is occurring at the moment. There was a period of time where, as you'd recall, I suspect that there were a number of matters going through the mental health court post conviction, resulting ultimately in acquittals after conviction by the Court of Appeal through issues like FASD and the inability to participate in the trial. This may pick it up earlier.
thank you.
Thanks, Your Honour, for the presentation today. If you could explain how the police fit into this, or how the police more are unable to access the evidence panel based on the legislation and the process of having to be a party to the matter.
The police are not necessarily directly able to access the panel for Stream 1 processes. The focus on Stream 1 is an activation on the behalf of the defendant, so will almost, one would think, invariably be coming from the defence representatives or a self-represented litigant, which poses its own issues. I would have thought that Stream 2 will provide much more opportunity for participation from QPS in accessing the panel to obtaining the evidence for the purposes of the brief. And indeed, as old-fashioned as it seems, I'd encourage that it happens early so that it's part of the disclosure at the committal stage rather than post-committal. But I really think, Stephen, that the access at QPS for stage 1 is going to be very limited. There will be, perhaps, occasions where the prosecution seek to refer a defendant, maybe self-represented, maybe not, where there is material of concern. That's almost perhaps not mirroring, but it does reflect those occasions which are relatively rare, where the prosecution refers to the mental health court at a later stage. So there may be that opportunity, but that will be fact dependent. And in that sense, perhaps QPS would also be involved at an early stage in that process. But otherwise, I think you need to sit tight for stream 2.
I might just also add to that, for stream 2, the prescribed places for use extend to the Magistrates Court in both Townsville and Brisbane, and the feeder courts that feed into that. So there is greater capacity for stream 2 for QPS to be involved in making referrals.
Anybody else?
Yes, thank you. This might be more of a legislation question, a panel-specific question, but just on 590BA regarding the notice after initial.
Yes.
I know that that section refers to notice, but doesn't really specify what will be part of that notice, which is in contrast to some of the other similar sections. Is it intended that that notice will contain the particulars of the defence or the impairment that's proposed to be relied on? Is it more to just put the Crown on notice that this may be coming down the pipeline? So.
I hadn't personally contemplated the difference, but you're right, the wording of the legislation does allow for simply a broad indication. I would have thought that if that had occurred, that the Crown would be marching over with a application for orders about discovery and so forth, so that the Crown can consider its position on getting a reply. But thank you for that. I hadn't thought about that aspect of it. I should say that the steering committee for the pilot project is an implementation steering committee. We had no involvement in the drafting of the legislation at all. It's a case of we are implementing what Parliament has passed.
Trixie, were there any questions online? No? Did anyone else have anything they'd like to ask while you've got the opportunity?
No?
No? Well, thank you very much for taking the time out of your busy schedules to be here today to find out some more information about our panel. If you go away and anything comes to mind over the coming days or weeks, please feel free to get in contact with the program team. We've got our flyers, which I believe have information on it, and there's if you haven't got the flyer, there's some just outside the door on the table, so please feel free to grab one on your way out. Thanks so much for your time.